Hi there, Marc Walker here, fitness to practice lawyer at What Rights. I wanted to have a quick chat just about interim orders, something that we have an awful lot of inquiries about across the regulators. Now, you'll find that regulators apply for an interim order during the course of fitness to practice proceedings when they feel that there's a risk associated with the practitioner's work such that they ought to be restricted whilst the investigation is ongoing. And a simple way of looking at it is something akin to bail conditions in criminal processes. So somebody gets spoken to by police, there's an ongoing investigation, and during the investigation the police wish to prevent either interruption to the investigation process or the commission of further offences. So to do that, they impose bail conditions. You have to abide by those bail conditions, and if you don't, you get yourself in further trouble. Well, interim restriction works a little bit like that. And as I say, the interim restriction regime is broadly similar across all of the regulators. What you're looking at when you hear that a regulator wishes to apply for an interim order, it is either interim restriction by way of conditions of practice. So that means that the registrant, the registered professional, can continue to work during the investigation, but subject to various stipulations. For example, they can only work for one employer. They can't work alone. They have to abide by an action plan and report in regularly to the regulator, that sort of thing. The second means of restriction is more onerous, and it's the restriction of suspension. And suspension means essentially that you can't work under your registration. So the impact of that, as you can imagine, is going to be significant, because it will mean that as long as that suspension order is in place, you can't work in your registered field, and you can't do so throughout what might be a lengthy investigation. Some of the investigations that we look at and we deal with, they can last for over 2 years, more, to go all of the way to a final hearing. So, as I say, that can be a particularly onerous restriction. And one thing that often goes with an application for an interim order is a very short lead up to the hearing to decide that application. So commonly, the regulator will receive a referral, they'll go through their triaging process, and they'll decide whether or not it's a case that requires that firstly can be accepted, and secondly, if it isn't one that can be accepted, whether there are risks associated with it that might mean an interim order is appropriate. And if they decide that it's a case where interim order might be appropriate, what will often happen is you'll get notification of the referral, and with that notification you'll also be told that the regulator is going to apply for an interim order, and they will generally give you less than 2 weeks before that hearing is to be held. So you receive a notification on the 5th of January, and they'll tell you, well, the hearing is going to be on the 19th of January or something of that nature. So if you get 2 weeks notice, that's probably what you're going to get at the outside. It could be 7 to 10 days. And so there's a limited time in which you can get prepared for that hearing. So it's essential, really, assuming that you don't have any experience with interim order hearings, to take advice immediately. Yeah, so as soon as you get that referral, get online, take recommendations, canvass the opinions of senior colleagues, and get some advice, because as you'll recall, the regulator could be asking for the suspension, and that really is going to cause you great difficulties. We deal with a lot of interim order hearings. We're constantly in hearings for them. This last year, so 2025, we were in hearings. When I say we were in hearings, I was in hearings for 80 plus days. A colleague of mine dealt with a few days worth of hearings for me. I was in hearings at 80 plus days, and I would say at least a quarter of those days were dedicated to interim order hearings. And so we know, firstly, how to respond quickly, so within that 7 to 14 days time frame, and also know what needs to be said and what you ought to avoid saying at an interim order hearing, in order to maximise the chances of being able to continue with your practice whilst you're under investigation. We've had some quite difficult cases, and we've had some cases, in fact, over this past year, where the regulator has come back for not just a second bite, but a third bite of the cherry. And in the particular case that I'm talking about, we were successful in defending the application for an interim suspension order in that particular case on all three occasions. So that registrant still practices without restriction. So we have a lot of experience in that area. We're able to react very quickly, and you need to react, as I say, very quickly to the regulator's indication that they want to apply for such an order. If you'd like to have some advice from us, you can reach out to us. We're very accessible, and we're happy to talk to you. We understand that these things are frightening, and they are shocking, and they are frightening. Nobody wants to have to be told that they're subject to a fitness to practice investigation, multiples in terms of magnitude, when you're told not only do they want to do that, but they want to restrict your practice in the meantime. So we understand all of that. We're thoroughly empathetic, and we fight your corner. We try to, and we frequently do avoid restriction at all, but at a minimum, enable you to continue working through something like conditions of practice. So I hope that's been helpful. A little bit impromptu, actually. I just decided about 10 minutes ago that I was that I ought to say something to help people with these fitness to practice processes. I've not done a video for a little while, so that's a little snippet. I think I will come back and perhaps give some more information about other parts of the process. Plainly, as registrants, you won't know the intricacies of a fitness to practice process. It might be helpful to have just a few insights to help you as you navigate them, or as you help somebody else navigate them. Okay, that's all for me. All the best, and I'll speak to you next time.